The only good idea is to let me and John do our job and mediate this thing right here.
You want to hear the crazy thing? I know it doesn't feel like it, but we're making progress.
Settle! Settle, 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 settle!
I don't want to settle.
All we're trying to say is, put your swords away for a second. Let's finish this and let's move on.
Welcome to Mediator in the Middle. This is your place to peek behind the curtain of what a mediator is really thinking. I'm your host, Abe Melamed, a litigator turned mediator. In this series, I, along with world-renowned mediators, will offer you, the clients, the lawyers, the parties to mediations, tips and tricks on how to be more effective in mediation and ultimately get yourself the best result possible. Thank you for listening. Please enjoy. Welcome back to Mediator in the Middle, a podcast about mediation by mediators for lawyers, their clients, anyone that participates in mediations regularly. I'm your host, Abe Melamed, and we are here today with a really special guest, and I mean that more now than I have in the past. No, I'm kidding. Every guest is a special guest, but Steve's a good friend, and Steve Pearl is maybe one of the country's top 5 class action mediators. He will object to that, but I will give him that designation.
No, I was going to object.
Oh, you were going to object? Okay, great.
That's tough to think that.
You were enjoying it ask him that in that intro. But no, Steve is really, truly an amazing mediator, and you have a ton of experience on the class action side in particular. I know you do some single plaintiff work also, but especially, large focus on class action. You've been full-time neutral for more than 10 years now, right?
Yeah, about 12
years. And before that, you did a lot of class work and, had your own practice. I know you had a little stint in big law, but your own practice on, wage and hour, employment, on competition, and consumer. So a wealth of experience, not just as a mediator, but as someone who's litigated these types of cases. And that's important, I think.
I'll do it.
Yeah, no, of course. And I also, just because the audience is going to likely be people that actually practice in the class action space, one of the markings that we all know is when a court recognizes you as a skilled mediator in justifying their, approval of a settlement that's negotiated through mediation. And so I know you've had several California courts and some others. I saw in Georgia, I saw... a couple others, but just recognizing you as a nationally renowned wage and hour class collective action mediator and, well-respected experience. These are some quotes from the actual court. So I think that's about all that you need to say to introduce you and the topic today, which is preparing for class action mediations and maximizing the process of a class action mediation, because I think that as mediators, we find oftentimes there are things that if a lawyer did more of or did differently, it could actually speed up the process. It can make it a more productive process. And so that's the key topic that we're going to talk about today. But anything in that bio that I missed that you want to mention, Steve? Anything important?
No, you had it. You did me out proud.
Good. I did you justice.
It's better. I Googled myself once. Do you ever do this? Do you ever Google yourself and just see what comes out?
I'm vain. Yeah, I do.
So I'm Googling myself, and I found this quote from a court in the Northern District of Georgia calling me like a nationally respected whatever. And it's just, I'm going to put that on my website. That's so great.
It's up there. Nationally renowned wage and hour / class collective action mediator.
Got where they've got, right?
Georgia.
Yeah.
Yeah, I mean, it's important for the litigants because if, one of the things we talk about is selecting the right mediator. The courts have to recognize it as a, legitimate and thorough and arm's length negotiation. And so if you've got a good mediator in your corner, I think it makes a big difference. But yeah,
for sure.
Leave it to the people in Georgia to have the best compliments, right?
Yeah, absolutely.
So tell me, this is the first kind of piece of this that I want to break down, but in your view, what is the most important information that you can gather? And maybe we have to be a little bit general, maybe we have to get a little bit specific to certain types of class actions, but starting kind of from the broad perspective, in any class action, what would you say are some of the things that the litigants on both sides need to work on gathering in advance of the mediation?
Yeah, well, it's a great question. and you have to know the metrics. Plaintiff's counsel has to know the metrics. Defense counsel has to provide that information, and the client has to provide that information. And so it depends, obviously, as you know, on the type of litigation. But if it's, for example, if it's a Fair Credit Reporting Act case where the allegation is that an employer had people sign authorizations that are not effective for whatever reason, then you got to know how many folks signed the authorizations, have their credit right? And that information is going to be in control of the defendant. And I don't know about you, but I get a lot of early mediations on these cases where folks haven't done the discovery yet, formal discovery, to find out that kind of information. And so it's produced very routinely, informally, because everybody knows that plaintiff's counsel has to have it. In a wage and hour class action case, plaintiffs need the number of putative class members, just like any other class action. You need the number of work weeks. So, for example, if you work at a place, Johnny's Ski Rentals for half the year, and I work there for half the year, that's one full year, right? We both work over the winter, 26 weeks for you, 26 for me. That's 52 work weeks total. And so that's usually the basic metric that people are working within. One of the basic metrics people are working with in a wage and hour class. In a PAGA action, let's say there's an arbitration agreement, so it's not going to be a class case, but plaintiffs brought it as a PAGA case. PAGA penalties, PAGA is the 2004 Labor Code and Prep Attorneys General Act, as folks know, I'm sure.
Yeah. Been in the news a lot. We all know.
There's a lot, right? Moriana and Adolf Super. So PAGA lives.
I guess both sides of the bar are happy about that, right?
Well, folks got to work. So in a PAGA case, the measure of damages is pay periods, because penalties approved by the pay period.
Right.
And so you got to know how many pay periods. So the work weeks aren't as important. The pay periods are what matters. Do you find ever that counsel sometimes are gathering the wrong set of data in these cases? Like this is a PAGA case, and they're pulling work weeks instead of the pay periods. Sometimes, but folks will just generally, do a 2-to-1 conversion, or sometimes we've got, like I had last week, a case where plaintiffs were claiming it was a 2802 only case. It was a class on PAGA 2802 only, and they were claiming that the reimbursement was due monthly. Cell phones, they alleged that folks had to use their cell phones at work. So, we just did a week we had the work weeks, or one side had work weeks, the other side had months. So we just did a conversion, and we were in the ballpark. So
fair enough.
For the most part, everybody knows what they need to get. The problems tend to be getting the information from the client, the defendant. Because sometimes you're dealing with small companies that just have a real tough time getting this stuff. And plaintiff's counsel, listen, for plaintiff's counsel out there, yes, sometimes your defense counsel is just not really paying attention to the case, and maybe they're kind of, not focused on it. Sometimes the defendant is working on it, and it's very tough to pull because, they don't have the staff available to do it, or maybe they've got legacy systems. Maybe they were working with Paychex and they switched to ADP, or vice versa, or whatever. They can't get the information from the prior payroll company. Maybe they used paper timesheets until they got a PAGA notice, and
suddenly everything changes.
Everything is it can be a big hassle for all of that stuff. It can be difficult to do, and sometimes, honestly, the clients just don't get why that's so important. And so sometimes, I get a call or an email a week or two before the mediation for plaintiff's counsel saying, "Hey, we haven't got the data to reach out to the defense. What's going on? My client, we're trying." We'll do our best. So
they may need the gentle nudge of the mediator to get there. And I love how you use the term legacy systems to describe archaic systems. But yes, it's and I do find I'm curious in your experience if you have the same problem, but I find that sometimes the lawyers, the day of the mediation, like if you get there and they haven't pulled all the data and it's because the clients have dragged their feet, they sometimes really do need you to lay out for them as the mediator why it's so important before they really make that move. And then a lot of times it's like, oh, now I get why we needed that, but now you're scrambling during a mediation to, call your accountant and get all this data, or call whoever it is.
Right.
And
yeah, absolutely. And I get that a lot when it comes to financial data, financial information. Because, financial realities, financial considerations play a real role in a lot of these cases. And there are a lot of companies out there that cannot afford to settle these cases at market rates, whatever those might be. And then I get a lot of business owners, small and medium-sized companies, where that's the case, and they haven't wanted to talk about their finances with the other side. And defense counsel might be reluctant for whatever reason. And it's not until you have a brass tacks kind of conversation about what the exposure is, like maybe there's a facial problem with the wage statements, or maybe there's a rounding problem that really appears to be a problem, or whatever it might be. Maybe, pick it. Maybe there's no problem, and we don't even have to get into the finances. We just have to, work it out. But very often I find that, you get a case where there's some value to it. Maybe it's not the value that the plaintiff's counsel ascribes to it, but there's value to it. And the only way it's going to get settled is if we talk about financials. And most often when financials are at play, they have not been exchanged in advance of mediation. And sometimes that's just because the lawyers are resisting it. Sometimes that's because the clients don't understand that they've got a real problem and they're going to have to share their financials.
Yeah.
Let me correct that. They don't have to. It's not that they have to. It's that it's in their best interest to. And that's what I explain to folks. Look, if you've got a real problem under California law that you're not going to be able to beat on a demur or a motion to strike or whatever on a summary judgment motion, and you're going to have to litigate this case, and you've got a good possibility or probability of losing, so that you're going to pay whatever penalty the courts award, and you're going to pay the other side's attorney fees, maybe it's in your best interest, your own financial best interest, to go ahead and share financials. I mean, it's uncomfortable. I wouldn't want to share my financials with anybody. I don't want with somebody who's suing me. Like, that's the last person I would want to share financials with. Right. Maybe it's actually
you don't want them to see what you're spending your money on. No, I'm kidding. But it's sensitive. It's a very sensitive topic, and I can understand a business, especially personal, right? Which is, in wage and hour cases with 558.1, you might have personal liability. You got to show that, and that's an even more uncomfortable thing than even your business is.
It is, and I get a lot of pushback on personal financials, and almost invariably, even when personal liability has been pled for business owners, a lot of times actually what defense counsel will do, and I think it's a smart way to handle it, is to just go ahead and provide corporate financials first. Mm-hmm. And if that doesn't answer, because a lot of times that answers the questions. Like, okay, you did X dollars in business, you lost X, last year. Year to date, you're down again. You're in the red 3 years running, whatever it might be. Okay, we really don't need to look at the personal financials, because we can see
probably not. Right.
The officer's compensation is $70,000, or anything, whatever, and there's no distribution to shareholders at the end of the day. Okay, you don't really.
We can get it. Yeah. And also, oftentimes in those cases, plaintiff's counsel has done somewhat of a basic search on assets. And we know you own one house, and maybe it's worth some money, but you got homestead for most of it. And we see you've got a car, but it's whatever. Yeah. It's not like you're driving Maseratis and owning multiple properties. We get it.
Right. So that business doesn't own the property where the business is. The equipment's leased, not owned.
Yeah.
Or it's owned, but it's all leaned out. There are UCC ones,
Yeah. But see, that's, I think the way you phrased that is the most critical piece, which is it's the help us help you process.
Absolutely.
The more that the lawyers can give us in the process to help them. So I do think, maybe it is an important takeaway for the litigators out there and for the clients who might be listening to this podcast, that it's not that we're asking to be invasive, to be difficult. And frankly, it's not even on the plaintiff side that they are. It's we're trying to figure out, give us any ammo to help us explain to the other side why this is a better, right? That's the BATNA. This is the best alternative to the opposite choice. And if it is like, look, plaintiff might go and take down $1 million verdict on a single plaintiff case, but you don't have that money to pay it, show it to them. And it's, look, I have a mediation later this afternoon where we finally got the P's and L's on the business on Friday. And a big piece of it was because there's been this whole big fight with the insurance company until now about coverage. And now there's reservation of right by the insurance company. They're taking a hardline position. And now it may require in the mediation that there be personal contribution from the business. And they're a small business. They're not, they're doing okay. But it took until literally right before to get even just the P's and L's. Mm-hmm. And I think it's because there's that resistance. Why we're not going to give it unless we need to. And then, So I think that's an important point. The more that they can give us in advance, and I think those are some specific things that I think it maybe come up more often in class actions than in other cases, especially because the exposure tends to be greater. So if you have a much bigger exposure, you might have a small business, right? I'm sure you deal with lots of small or medium-sized businesses. This is the very first PAGA or class action they've ever faced. Yeah. And now they have to make some real hard decisions, right?
Yeah, absolutely. Absolutely. And go back to something you said, the help me help you thing. Sometimes the reason that the financials aren't produced is because they, folks don't understand that it's important, why it's necessary. But the only way that you're going to explain that to folks effectively is if they understand that you as the mediator are there to help them, right?
Right.
That's the key. That's the key to the whole process working. And that's such an interesting part of the process, right? Because there's no one way there. Mm-hmm. You're dealing with different people every day, right? That's a big part of what's interesting about this process. You're dealing with different situations, different people every day. Maybe one day I've got plaintiff's counsel who's an operator and they don't want to talk about anything. They just think that's really come to her and they don't care.
I don't care. Just give me the number.
Right. Or maybe another way, like I had both of these last week. I had an extremely emotional plaintiff, very heavily affected, she said, by what happened at work, defense set by other stressors, alternate stressors, regardless of what it is. To me, a person who, I really had to handle with kid gloves and did. And on the other side, you can have similar differences. You might have associate general counsel because it's a larger organization, and this is just one of a portfolio of cases they have. Of course, they care about it; it matters to them. Their job performance depends on settling the case at the right number,
right?
So it matters. Or you might have somebody who, like you just described, it's a small business; they've never dealt with this before. And they come into mediation thinking, oh my God, this is going to bankrupt my company that my grandfather started.
Right.
And what am I going to do? What am I going to do here? There's no way out of this. And so we deal with all these different types of people in different situations who are coming into mediation with their own concerns, their own emotions, their own backgrounds, and everything. And the lawyers are trusting you to come into the room with that person.
Yeah. Establish rapport, establish credibility, and let them understand that you are really there to help them. I think that's another really important tip for the litigators out there is that you might be like that GC you described where you've got a dozen of these types of cases and this is one more on your docket, but recognize that the parties are new parties. The process won't necessarily go exactly how it did last week or the week before, and be willing to adapt and being willing to just kind of go with the flow is so critical. I think that's what makes some of the best meetings, right?
I love that, and that's something that we try to. I do this mediation program. It's to teach lawyers to do a better job in mediation.
Yeah.
Through California Lawyers Association. I'm doing it annually now. This year can I plug it?
Please, go for it. We're at the time right now. Plug. If you want a discount code, go to.
I've got no discount codes. I'm sorry, but yes, the program is this year is December 5th. We're going to be doing it at Works offices. Work very generously offered to provide their offices in San Francisco. So we're going to do it in person, and CLA is going to webcast it. So we get the best of both worlds. It's a full day conference, and we have mediators and plaintiffs' attorneys and defense attorneys all working together to teach folks to do a better job in mediation. And one of the things I really stress is that every mediation gives you the opportunity as counsel to look freshly at how you want to handle it. Do I want to do things in this mediation differently from what I normally do? Right? We all have patterns, things we like to do, we don't like to do. We don't like to do joint session. We don't like to share our briefs. We do like to share our briefs. We do this, we do that. Really analyze each day out. What are the considerations behind each of those decisions? And is there an opportunity here to do something differently because the case is different? Right? Do I have a plaintiff who's a knockout that the other side hasn't met? Just an incredible plaintiff that I want the other side to meet. Maybe I never, ever do joint sessions, but maybe this is that case. Joint session. Yeah. Right. Or an alleged bad actor. We just is nobody's going to believe that this person did these things. I want to bring that person into a joint session and just sit and let plaintiff's counsel ask a few questions. Do I want to share briefs because I'm not assigning real or market value to this case? I'm assigning, as plaintiff's counsel, I'm assigning higher than normal market value, and I want to make sure that this makes it to the adjuster, right? In a FEHA case, or I'm assigning less value than normal, and I want that to be a surprise to plaintiff's counsel. So maybe this is a day as defense counsel where I share some additional information beyond what I normally share. Yeah. So anyway, those are the kinds of things that we talk about in the conference, among others.
I 100% agree. Being willing to change your process and roll with the process if it's necessary is critical. Yeah. So in class actions, can you think of anything? I want to talk a little bit about, for example, coming in, having already drafted an MOU or having an understanding of what kind of the structure would look like. But if you were to focus on that, aside from gathering the financial information, doing an exposure analysis, which we'll talk about towards the end of this podcast, but beyond that, in the prep phase, is there anything else in particular you say, lawyers, you should be doing more of this, or frankly, lawyers, you should be doing less of this?
I would always encourage folks to exchange MOU, send an MOU. It's really no big deal. Everybody's seen them. Everybody's worked with the same forms basically anyway. So, get what you want out there and have a conversation about it. It doesn't indicate weakness. It's just preparation, so that you don't have to do it at 5 or 6 or 7 at night. Yeah. And you can leave the mediation with something signed. Always encourage folks to do that.
And there are often terms, I always found this interesting in single plaintiff cases where it's like the most basic terms, are there going to be liquidated damages associated with a breach? Or what is the tax allocation going to be, or whatever it might be. And I saw, when I was a plaintiff's lawyer, because I worked on both sides of the bar, but when I was a plaintiff's lawyer, what I found was if we negotiated these terms the day of the mediation, they were easy as pie. The GC is in the room, they can make those decisions and we're done. If not, it spent weeks and weeks of redlining the agreement back and forth, and sometimes it was a hardline position. And now as a mediator, I see it even more because a lot of times it would be the mediator was able to mediate those issues, right? Okay, you don't want liquidated damages. Tell me why. You want liquidated damages. Tell me why. Okay, well, maybe we can come up with some middle ground of a lower amount in the liquidated damages clause, or, Right. So I think that having an understanding of some of those terms in advance is really critical. What I'm also curious about your view on, though, is I have this theory that if the parties can negotiate some of the non-monetary terms first, it just gets them thinking about this case as something that's going to settle. It's like, okay, we got through, the thresholds, we got through the escalator clause, we know what, now let's talk numbers. What are your thoughts on that? Do you do that?
No, absolutely. It's confidence building measures, which you see all the time in international diplomacy. Yeah, we're gonna find something small that we can agree on relatively easily, and we're gonna agree on that because it starts the process of agreeing on things. It's like convenient is called, somebody called it the cascade of yeses, right? So you just agree. Yeah, just to grab, I think Ralph Williams gave me
It's
that.
a Ralph Williams quote. I'll have to
Yeah,
add
it
Ralph.
was
Ralph's great.
a lovely guy, wonderful,
Yeah.
fantastic mediator, and I was very fortunate to have him as a mentor.
But yeah, I mean, the term I think of is Dave Ramsey talks about getting out of credit card debt as a snowball effect. And so you might think that it's logical to start with the highest interest rate, but if that's the biggest payment, you may get, frightened by it. So just pay off the smallest amount first, and it just creates a snowball effect. So that's how I kind of think about it. And I've toyed with it a little bit. I've done some of that. I do find that a lot of times, especially in the defense room, but I guess on both sides, there's some, pushback to, well, we're not there yet, and we don't even want to, make it seem like we're ready to settle this case. But especially with the big class actions, and everyone knows we want to try to get this settled, and the terms are going to tend to be the same, I think it makes more sense. Are you finding the same kind of pushback in mediations, or do you have some counsel who are okay with it?
I think mostly folks are just working on other stuff. They just don't get around to it, honestly. I think folks are so busy, and that's to me what it seems like.
Yeah, it could just be being busy. Everyone's busy.
But I'm like you. I like to keep the Zoom open. Almost everything I'm doing has been by Zoom. I've done 6 mediations at person in 3.5 years.
Wow.
But I'm happy to keep the room open and keep working until we get the MOU, or we're doing a long form. My preference is always to get that done that night. Sometimes folks will say to me, not a big deal. We've worked together, playing defense counsel, and we'll just email it tomorrow.
Yeah.
Of course, that's fine. But I always like to have something signed that night.
Yeah. Yeah. I find that especially in cases that are headed towards a mediator's proposal, as we get towards that stage where I start setting it up on both sides, that's where I'll say to defense counsel, hey, send over a draft to the other side. Let's just get this started and, just leave the number blank type of thing.
Yeah, at 100%. I frankly, I'll have people sometimes ask me to do the MOU. I don't want to do the MOU.
Yeah.
And it's not because I'm lazy. It's because the person drafting the MOU is controlling material terms of the settlement.
Yeah.
And controlling the material terms of the settlement is not my job.
Yeah.
I'm a neutral. So, I don't want to be setting those terms. You set those terms. And whoever wants to break first, go ahead. Other side can object to whatever they want to object to, and we'll sort it out that way. I do the same thing.
So when you say we'll sort it out, later that way. So I'd like to think that those are some of the terms that we tend to have some disagreement about. Why don't we talk about that for a second? What are some of the things you see and let's, focus maybe for a second on PAGA cases?
Sure.
Certain terms in the MOU or in the full length that tend to be something that needs to be negotiated through the mediation process?
Yeah. So, for example, escalator clauses. Escalator clauses used to be a little bit unique. You didn't see them all the time. Now they're in every settlement agreement.
For the lay audience who's not familiar with it, why don't we outline what an escalator clause is?
So defense has told plaintiff that there are 10,000 work weeks in the PAGA period, in the class period, or 10,000 pay periods in the PAGA period, or 500 employees. And it turns out there are twice that many. Well, the settlement that was negotiated in mediation isn't going to work because it was in reliance on it being X, not 2X. And so the escalator clause says, if it turns out that the actual numbers are more than a certain percentage above what's been represented or what we've agreed upon, then the settlement goes up proportionally. And so very often plaintiff's counsel will ask for a 5% buffer, the defense counsel will ask for a 10% buffer, and the meaning of the buffer is, let's say we agreed it was 10,000 work weeks, a 10% buffer would be another 1,000 work weeks. So as long as it's less than 1,000 work weeks, the settlement is not going to go up. But if it's 12,000 work weeks, and this is the way that most of them are written now. If it's 12,000 work weeks, that's 1,000 on top of the 11,000. So he's going to get another
buffer. You deduct the buffer. You don't
increase the buffer, no increase for that, but a 10% increase because it's another 1,000 above that.
Right. And kind of the converse of that, I think, would be thresholds. So why don't we talk about that for a second?
Like for a blow-up clause or what?
or generally for a threshold of participants in the class in order to.
Well, that's funny because in a consumer, you're talking about claims made, so you got a threshold where it becomes effective.
Right.
And in an opt-out class, or in a typical wage an hour, you don't have a threshold like that because you're not doing claims made settlements anymore.
Right.
We used to do them. So you've got an opt-out threshold, and the discussion will be, defense counsel will want a 5% or maybe lower threshold, where if 5%, for example, of the class opt out, then defense has the option to blow it up. And plaintiff's counsel might say, no, we need it higher.
It's also interesting what the competing interests are there, because in those instances where it's, claims made and you're having people that are, you need to meet the threshold, it's often on the defense side that they want the finality of this actually resolving every claim that there is. So for them, they may have a higher threshold they want to see, where the plaintiff's like, well, no, if 60% of the class agrees, we want our, we still want our fee, the employers still want their fees, and
Right. We were talking off camera, I guess, about Lowry, the Ninth Circuit case, where the court held in a consumer class. It was a copyright case, and the Ninth Circuit held that the touchstone for determining the attorney fees is the actual benefit to the class. The parties had agreed that the hypothetical benefit to the class was $20 million. But 98% of the class had already agreed to be part of a separate settlement.
Yeah,
were already taking place, so they knew that $20 million grant would never be met. And in fact, $50,000 ended up being distributed to the class. $52,000. I was just reading it again. The district court awarded $1.7 million, I think, in attorney fees. And the Ninth Circuit said, no, the touchstone has to be not the lodestar, even though it's a fee shifting case, not the lodestar, but the actual benefit to the class, and not the hypothetical $20 million benefit, the actual benefit.
Right.
So it's a situation where the reason I raise it is because it's a situation where, plaintiffs' counsel, they may not want a higher threshold number in the MOU or in the settlement agreement, but in reality, they may be pushing for a higher participation rate.
Right.
And so then the question is, how do you deal with that on defense?
Yeah. Yeah. And I think, it's interesting that that's maybe proliferated some of the mass ARB cases, where you'll have plaintiffs' counsel that will say, we want to actually create the benefit to our group, and we want to be able to justify those fees, although you may not have to justify them in the same way, but if it's going to be confirmed or whatever it may be. But it's being able to say, we don't need a seat at the steering committee. We don't need to be, involved. We'll take our 600, our 1,000 plaintiffs and bring them in a mass ARB, and we are actually contributing to the outcomes there. And I think you find a lot of other interesting issues that come up then, because you might have the same defense firm, different plaintiffs firm, totally different size, different negotiation, totally different MOU.
Yeah, well, that's for sure. It's a very, it's a real interesting phenomenon, the growth of mass arbitration.
Yeah, especially in data breach cases. And I find that that's maybe one of the areas where you see more of it. So let's talk for a second just about the negotiation process. In your view, what is the best way for the parties to come in a class action specifically and start the negotiation? Do you like to start within a bracket? Do you like to start with brackets? How do you view it, as someone who does a lot of class work, as the best process of negotiation?
So, most folks are gonna start the way they always do. Most plaintiffs are gonna start with relatively high demand that's not particularly close to anything that they would settle the case for, and everybody knows it. I try to talk to folks about making those offers that at least are in the parking lot. And sometimes folks are willing to do that, and then I go and get an offer that's the same way. What's interesting, I don't know if this is your experience, but when folks have negotiated a bracket before the mediation, those are some of my toughest mediations. And I'm not entirely sure why. It seems like different issues arise. I did have one in a FEHA case This woman had gotten cancer. She was a very highly compensated employee. She'd gotten cancer and she'd been terminated. They said, the company said, for other legitimate business reasons. But the parties had agreed to a very high range for the negotiations, and the case settled very quickly. The company had a real problem in that case. But in other cases that I've had where folks have agreed on a bracket or range in advance, we've had some very, very tough negotiations.
It could be.
Right.
It could be that listening to it, it could be that it's because both parties are trying to negotiate away from the midpoint, right?
Well,
and
that's
so
for sure.
you come in with the bracket, and everyone on both sides is trying to say, but that's not the midpoint. But we all kind of know that's what seems to be said in that bracket. Whereas if you do it more naturally in the negotiation process, so plaintiff might offer a bracket, defendant's not going to accept that bracket, but they'll counter with a bracket, and now we maybe have some other data sets that we can look at, and some people are only looking at the midpoints. And the midpoints, Ralph would talk about, the bottom and the top numbers and all that. So it kind of depends on what the goal of the brackets is, and maybe that's the most important thing, is setting the ground rules of what we're doing with these brackets. But yeah, I think that's when you walk in with plaintiffs at, $2 million and the defendant have to be at 500,000 and, you're at a 2.5 million. So everyone's thinking 1.25 and plaintiff wants to get 2 and defendants want to, knock it down to 1. And so that's, that might be.
You know what I think part of the problem is, Abe, honestly?
Yeah.
I think it's the communication. I think that one of the big reasons why folks hire us is because lawyers now are not real comfortable talking to each other, and they don't do a real good job. They don't do a real good job of expressing themselves clearly about what it is they're trying to accomplish. And I think that one of the things we can do as mediators, one of the things we do as mediators, is to communicate effectively what needs to be communicated with a given offer or a given demand. The demand is X, but look, this is just their opening demand. Please don't put too much importance on this number. This is not their final number. This is not what they're looking for. Everybody knows you're not going to pay.
Yeah.
So the offer is Y. Nobody thinks that you're going to accept this, Mr. So-and-so, who's got an individual case. Please don't put too much focus on this. Or plaintiff has proposed a bracket between X and Y. This is what a bracket is. This is what it means. And, if they know that you're not going to accept this bracket, the most common response is to counter with a different bracket, and then we can go from there. Or defendant's bracket in response is this, and they ask me to let you know that they are not looking at the midpoint of the midpoints. They do not have authority to go to the midpoint of the midpoints, and they're not going to. And I think what actually happens when lawyers are talking to each other a lot of the time is that they're not conveying that information. And so they get into mediation, and a lot of the communication, the preparatory communication, is missing. And so they've gotten themselves wedged into a situation like, demand was 5, offers 100, and midpoint's obviously 3, and we're not going with every 3, and we're not going to match 3, but they haven't really talked about what it is they're trying to do. And I think it's less effective when folks do that than when they come into mediation and communicate with us, because they're willing to communicate more openly with us than they're willing to communicate with each other. So it gives us an opportunity to really lay out for people what's going on in a way that doesn't happen when they're talking to each other. And I think that's the problem.
Yeah. When they have to be positional, I think it makes it harder for them to communicate it. And, one of the things that I actually love to see the litigators in the process do is give me, as the mediator, some of that justification or some of that explanation. Like if you have a defense attorney who says, hey, listen, communicate to them that our counter offer to that is $50,000, but I want you to tell them why. The reason why it is because we have looked at their lost wages, and we are assuming that we want to make them whole. And we do recognize that there's some emotional distress. And now, I mean, obviously, if they don't say that as the mediator, we might do this anyway, kind of, dress it up a little bit. But when we can genuinely say, look, defense counsel is communicating this and defendant, the actual client's communicating this, and it means something, especially because in reality, in the plaintiff's room, there's always the underlying need beneath the presenting symptom, if you will. So being able to communicate that information on both sides is, I think, really helpful. And I think the same thing from the plaintiff side. And that, kind of is a great segue into the damages, the exposure analysis piece of this. But, coming in with just an obscene demand that has no basis in reality and no connection to any practical numbers, the defense room, like, well, how did you get to that number? Can you explain that to me? And so I think that the more that people can explain it, even if it really is the most liberal analysis you can ever possibly place on the case, but at least identify it, at least explain how it is that there's a world in which you might get that. And then I think it plays a lot better in the other room. So that's a good segue into that topic. But what is your view, or do you prepare the parties coming into mediation to give some sort of a damages exposure analysis?
So in a class case, I almost always have that. I can't think of the last time in a class or PAGA case that I didn't have an exposure analysis. Most often prepared by one particular company. They do a fine job. I almost always have an exposure analysis. It's almost always higher than anything that plaintiff could actually recover. It's always a 100% analysis, and that's perfectly fine. I used to get, in PAGA cases, I used to always get analyses that had multiple PAGA penalties, 5, 6, 7 penalties for different things, usually non-multiple penalties for a single course of conduct. More about that in a sec. But always at initial and subsequent violation rates. But now, since gone through a California Court of Appeal case, most of the analyses come in with just initial violation rates. Right. Still stacked. And there is some appellate authority for stacking PAGA penalties, by the way. Thurman versus Bay Shore Transit, Amaral versus Cintas, among other cases. So anyway, there is some authority. Most of the authority on stacking is in the remand context. Right. And it's really not the best authority in my view, and there were cases on both sides of that.
But do you find, just to ask about that for a second, because I've had this come up a couple of times, do you find sometimes that exposure analysis has multiple violations, and then when you get into the facts of it, really there's only 3 clear-cut violations, but the 4th and 5th, like the wage statements are almost always, you're going to always get hit with those. There's going to be an inaccuracy there, but like whatever it might be, right, or in the class context also, but, we really don't have any evidence to show rest break violations. Maybe we have some for meal breaks. Maybe we have some for overtime. So when you come in with that analysis and the defendants say, you're factoring in everything, and we all know that that's not as clear cut, I think it has less impact than it would if you said, let's say, for example, this is kind of the credibility building, but if you said as a plaintiff's attorney, look, we're going to assume 100% of overtime and 100% of meal breaks, every meal break they missed and every, for the entire look back period, but we're going to concede that there's really not a lot to support the rest breaks because you got a clear policy in your handbook and they've signing waivers and, so we're going to make the analysis as liberal as possible on the 3 categories we do really believe in, but we're not, and so the number is still going to be astronomical, still going to be way higher than we're ever going to recover and the defendants are ever going to pay, but we're being a little more candid, if you will. I find that to be so much more helpful as a mediator in negotiating it in the defense room. What's your experience?
Yeah, usually that's in the, what I've found is usually that's in the demand phase rather than the exposure analysis phase. So mostly the exposure analyses that I see are full, fair, even if plaintiff's counsel admits to me confidentially that, they're probably not going to certify the off-the-clock claim or prevail on the rest period claim or whatever it might be. but they've got a real strong argument for a regular rate case or whatever. And, but that's usually coming out in the wash of the negotiations,
Right.
and not so much in the exposure analysis. And I'm literally, if I'm dealing with anybody other than a professional negotiator in the other room, general counsel, on the defense side, I will tell folks, please don't pay too much attention to these numbers, because you see, and actually, depending on the situation, I may not go through plaintiff's exposure analysis, and I'll tell plaintiff's counsel, I'm not going to go through this exposure analysis in the other room, because it's just going to shut this person down and make it more difficult for you to settle your case. So, because you can see when people just lose it and like, oh my God, you're going to shut down my business. And some plaintiff's counsel might feel like, well, that's exactly what I want you to do.
Right.
It's actually, my goal in mediation is to get to a place where it makes good business sense for both sides to get things resolved, right? If it makes good business sense for the plaintiff, it makes good business sense for the defendant, that's a good deal. And when you overload people with too much emotion, you flood their brains with cortisol and bodies with cortisol, you impair the ability to make good business decisions. I want them to know that I'm going to do everything I can to get the case to a place where it makes good business sense for both sides to resolve it. It has to work for both sides, or it's not going to settle, and that they can trust me to do that. And the truth of the matter is, they can trust me to do that. Mm-hmm. And it's interesting where I'm finding for myself as a mediator at this age and at this point in my professional life is I am more and more confident all the time in my ability to get folks there. Like, I had somebody trying to walk out the other day, and it's like, no, we're not doing that. We're going to stay here and we're going to work on this and we're going to get this case resolved. Like, we're not actually, numbers are far apart right now, but we're not actually that far apart. And we're going to get this case resolved today. And, and they settled down and we did actually get the case resolved. And that's what happens the vast majority of days. Yeah. And that's what I'm finding.
You got to make sure that's why you got to make sure people are eating food. You got to make sure they're as relaxed as possible. And, I think telling them, I did a mock mediation with a plaintiff's lawyer, Mona Teshrudian, and Jeff Thorell at Fisher Phillips. And, in negotiation, Jeff was like, I'm going to just ignore the plaintiff's opening number. Pretend it doesn't exist. Here's my first offer. And I started to use that as kind of just the way I communicated to the defense room. Like, ignore their offer, ignore the demand. It doesn't matter. It's monopoly money. It's fictional. We all know, and don't come back to me. The first person to be brave in the negotiation controls it. Don't come back to me with monopoly money,
right.
So.
No, that's two good points. One is that the science actually shows that the way to deal with anchoring, because numbers do have an anchoring effect. There's so many studies on anchoring, and they're all like kind of mind-boggling. You can't believe the results. But the best way to deal with anchoring is to vocalize that I am not paying any attention to that no.
Yeah.
And then number two, you're absolutely right. The party that gets closest to the playing field first, or the party that gets onto the playing field first, controls the playing field. So very smart defense counsel will put a big chunk of what they have on the table right off the bat, in a pocket case or an individual case, class case or an individual case.
Yeah.
Because number one, you get the attention of the folks in the other room. You're really there, and you control the playing field by doing it.
Yeah.
You're anchoring the playing field.
Yeah. And then and then the skill of the mediator is often to communicate that is not in any way a low offer that they're going to then double and triple and quadruple, but they've actually put a big chunk of their money on the table.
Right.
That's where the messaging really comes in. It's, look, we're acknowledging why we're paying you this much even to begin with. And, yes, there's still room to move, but we're putting it out there,
Yeah.
Yeah.
Yeah. And they have to let you know that that's what they're doing. And they have to, stick with that if that's what they're doing.
Yeah. I'll tell you on the damages or the exposure analysis piece, just to kind of close it out, I think that what I found most interesting recently is a lot of times you come in a class case and there isn't really an explanation for why the number is what it is. The plaintiff wants to maximize the settlement, and so their demand is just astronomical, and they can't explain why it is there. And at some point in front of a court, you're going to have to justify it. And so that's an important piece of it. But it really does make a difference, I think, in the defense room, right? Like in data breach cases, that's an example, and I'm writing an article about this right now. There's a lot of analysis about standing in the data breach context, and I actually made the law on that in the Second Circuit. And there's an analysis about what is the quality of the data that's been stolen. Has it been stolen as a result of a nefarious hack? Have people already had their data stolen or their data misused in some way? So it makes it more likely that someone who hasn't yet is going to have it. And instead of coming in and explaining why all those factors are ticked off in this case and why it is that this is a case where all the plaintiffs are going to have standing and why the damages might be greater and what they're going to spend on protections are going to be greater and what the fear they're going to have is greater, they just kind of come in and say, well, last case we got X, so this case we want Y, And so I think that's something that I would like to see more lawyers doing in the process is, again, it really is about arming us as the mediators with as much information, as much ammunition in each room. And the more that we can go into the other room and justify it or explain it, even if it's not anywhere near where it's going to settle, but it's exactly like you just said, like you go into the defense room and you just say some astronomical number that could bankrupt the business and people start getting angry and upset. And, whereas it's like, look, they're here to settle this. It's not going to be that, but we want you to understand why it is that they're making that demand and why it's not a crazy idea. So let's talk about that. I think then in the other room, they understand, okay, look, I get it. It's not just a plaintiff's counsel trying to take advantage of us or something like that. So I find that the more that lawyers can do that, I think it's better for us. What's your experience on that front?
Yeah, I agree. Yeah, and the other side may still, think that it's a crazy demand, and that may be their response. This is absurd, and it's never going to happen, and the offer is X, and and that's all fine. But I agree with you. It's helpful. It's helpful to have an explanation for why you're coming in.
Yeah, and the only other thing I wanted to point out from what you said, because I think it was so spot on, is that you really don't want to create that alienation between the parties and create this anger. And that's one of the reasons why I think joint sessions are so uncommon these days, is because it was like you bring the lawyers together, you let them yell at each other, and then you separate them and say, settle the case. It just doesn't work. And so anything that we can do as mediators and anything that we can do as litigators, I do think that some of the things you talked about earlier, like sharing the briefs or whatever it might be, that allows you to, communicate to both sides. We want to settle this. We need some help. We need the mediator to help us settle this, but we do want to try to get this resolved with you. I think it makes a huge difference in the process. That's my experience.
Yeah.
So.
Yeah. I'm not saying that parties shouldn't share their briefs in every case. I frankly, for myself, I prefer it if the parties don't share briefs. I know other people feel differently. I find I enjoy the process of sharing what plaintiff has to say and then sharing what defendant has to say and doing that back and forth. I feel like it grounds me in the case and it helps me understand the case better, so that when we get to the point of me giving some reactions to it, if that's what's appropriate, I'm better grounded in the case. So I actually, I don't really like when parties share the briefs, because we skip to step 3 without having gone through 1 and 2 with me. But there are cases where that might be the best thing to do. And so I'm just saying, think about your case critically every time out, and think about where you might want to deviate from your standard procedure.
Yeah. No, and I think that's a really great point, especially when you need catharsis in either or both rooms, because that is a huge piece of what we do as a mediator, is giving the parties that catharsis. My final question, and I ask this of every guest, what is it about the mediation process you love? What kind of keeps you going every day?
I mean, I don't remember if we talked about it on camera or off, but the trust that the lawyers put in us, to come in and work with them and work with their clients is extraordinary. They trust us to represent them in the other room and to listen to their clients, trust us with those relationships. I really value that. I love the intellectually, the work is fantastic. It's incredible. You get new wrinkles. I go back and read cases that I haven't read in years, Is there some issue like I've got the basics are broke down, and but there are cases I haven't read in a while, or there's a new issue that I haven't looked at, and so we're always learning or relearning things. That's so intellectually that part is great.
Yeah,
I love the numbers.
Do you?
Oh yeah, I love numbers. I love the.
I always joke like I went to law school, not math school, for a reason. But yeah, I mean, you hold up a legal pad with numbers scribbled everywhere.
I love that. I love that, and I love it when parties trust me to tell me what it is they're trying to get to, and then I can collaborate with them on how to get there.
Mm-hmm.
I really enjoy that a lot. And then, of course, the sense of accomplishment at the end of the day.
Yeah.
The case is resolved, especially if it was a tough one, especially if the parties were skeptical that it would get done, which they very often are.
Yeah.
Unless you've got, real pros in both rooms who have worked together before.
Even then, I think it's like 25% of the time where I walked out, I'm like, yeah, that was kind of easy. Anyone have 75% of the time, like no one thinks it's going to sell till the last 10 minutes.
Yeah, on those really challenging days when you're even doubting yourself, and then it comes together. And
yeah,
it's like, damn, I did a nice job here. I did a really nice job there, and I did a great job closing.
Yep.
I love that sense of accomplishment.
Yeah.
I mean, I just feel lucky to get to do it. Quick story. I'll tell you a quick
Yeah,
story.
please. Absolutely.
The very first case I ever mediated, I was on the phone with my friend who was a plaintiff's lawyer. He had a friend who he was helping out. And he said to me, I got a demand letter from this guy. It's like, do you know this guy? And that's my friend, but so what is our case? And I don't know, maybe I suggested it, maybe one of them suggested it, that I mediated the case. And this is like 2008. And I had not ever mediated before. And so we get together in my conference room, a couple conference rooms in my office, and we worked on it all day. We went until, 10, 11 at night, whatever it was. And we got the case resolved. And I had a migraine. I felt terrible. I don't even know if I went to live the right study, but we got the case resolved. And then it sat for a couple of years, and I didn't do anything with it. I have my own, I have my practice, and I wasn't thinking about mediation. And then David called me, and he told me that he was going to take the course at Pepperdine, mediating the litigated case. And he's like, you should come with me. I ended up going, and I loved it. The course was shepherded by a guy named Tim Poundall at Pepperdine, who since has passed. And Tim was absolutely incredible. Lovely human being, incredible mediator. And in community mediations, he would go into communities in conflict and do faith-based mediations, faith-based conflict resolution. He told us about mediating the case in the Punjab, where the men he was working with left their AK-47s at the door.
Wow.
Came in, and on the basis of their shared beliefs, he was able to bring them closer and settle, in broker peace, but he was able to bring them closer. And so just an incredible, and I've had, in my own little way for the last 12, 13 years, been able to play out the same thing in my mediations where, folks come in, it's not the same. I can't claim to be doing the same work that Tim did, because that was so extraordinary. But in our own little way, we get to do the same thing. We get to lay things to rest for folks. folks, right? We get to bring them some peace in their lives. For the plaintiff who doesn't have to worry about this anymore, doesn't have to carry the shame and the guilt of, I allowed myself to be harassed or discriminated against, which is how people feel coming in. Or for the small business owner who no longer has to worry about whether their company is going to be bankrupt, that their father or grandfather or grandmother founded. To put those situations to rest, to help in that process is like incredible. And I just feel beyond blessed to get to do that work.
Be able to do it. They get to walk out and say, you know what, you helped us get this resolved and we appreciate it. And that's the best, Well, I appreciate it. I appreciate you taking so much time and being here. I know the listeners and viewers will, gain a lot from it. And so thank you so much, Steve. Without an audience, we would be nothing. So I'd like to thank you, the listener, for tuning in to another episode of Mediator in the Middle. Please take the time to subscribe on your favorite podcast platform, Spotify, Apple, whatever it might be. And please feel free to refer a friend. Until next time, we look forward to seeing you, and keep calm and mediate on. Thank you.